Okay, class, today is the scheduled day for oral recitation. Please prepare yourselves as we start. So, the open for everyone question. What is stated in the Article 1262?
Article 1262, Section 2, Laws of the Thing Due, is the article that explains that an obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor and before he has incurred in delay.
Excuse me, Prof, if I may add, in Article 1262, Section 2, Laws of the Thing Due, which also stated that when by law or stipulation, the obligor is liable even for fortuitous events. The loss of the thing does not extinguish the obligation, and he shall be responsible for damages. The same rule applies when the nature of the obligation requires the assumption of risk.
Correct! Miss Pagunsan, what does it mean when a thing is considered lost?
Loss of a determinate thing under Article 1262 is the equivalent of impossibility of performance in obligations referred to in Article 1266. But, loss of the thing due, as used in Article 1231 and the above section subtitle, extends to both obligations to give and obligations to do.
Correct again! Now, when can we say that the loss of the thing will extinguish an obligation to give? Elaborate or provide an example.
The obligation to deliver is specific, a determinate thing. An example is promising my sister to give her the purple bracelet I made myself. Second, the loss of the thing occurs without the fault of the debtor. Example, the product gets struck by a lightning. Third, the debtor is not guilty of delay. Example, if the delivery company failed to deliver the package on time or unharmed.
Outstanding! So now, in what circumstances can we say that the loss of the thing will not extinguish the liability? Elaborate or provide an example. Let's start with Micaela.
First, when the law so provides. This means that the obligor is liable even for fortuitous events, because it is provided by the law.
Second, when the stipulation so provides, delivery of the thing must be made despite fortuitous events.
Third, when the nature of the obligation requires the assumption of risk. For example, delivering goods that are perishable and thus need to be delivered before the expiration date.
Last but not the least, when the obligation to deliver a specific thing arises from a crime. Even if the obliger has nothing to do with the damages, he or she is still liable. An example is an obligation that arises from an act punishable by law.
Very good! Now, Person A obliged himself to deliver C, a Mitsubishi Montero car model 2022 on December 20, 2022. However, the car got lost due to a fortuitous event. In this case, the obligation is not extinguished because the thing or the object promised is generic or indeterminate. The question is person A still obliged to find another Mitsubishi Montero car model 2022? What do you think, Miss Sommelier?
Yes, Miss. Person A is still obliged to find another Mitsubishi Montero car 2022. According to Article 1262, Section 2, a thing is considered lost when it is understood that a thing is lost when it purchased or goes out of commerce or disappears in such way that its existence is unknown or cannot be recovered.
Excellent, class. I can see that all of you did your studies very well. So let's end our oral recitation as we proceed to our next lesson. We'll be talking about Article 1263. In an obligation to deliver a generic thing, the loss or destruction of anything of the same kind does not extinguish the obligation. So, where do you think, class, this principle applies to? Yes, Miss Micaela.
It is based on the principle that a generic thing never perishes. The debtor can still be compelled to deliver the thing of the same kind. However, the creditor cannot demand a thing of superior quality, and neither can the debtor deliver a thing of inferior quality.
Correct. It is actually an example of a case where the debtor is still liable even for a fortuitous event, class. Let's just say your classmate Trixie obliged herself to deliver Alyssa 2 sacks of rice to her residence the following week. However, the sack of rice was washed away due to Typhoon Odette. When the supposed day of the delivery came, Alyssa was furious that Trixie could not fulfill her promise. In that situation, is Trixie still liable to Alyssa, even if the object of the obligation was lost due to a fortuitous event? Yes, Miss Pagunsay?
Yes, miss. This is because her obligation was to deliver a generic thing. By the principle of genus non quam perit, that generic never perish, she is still liable to Alyssa.
That's correct, because class, the thing is generic. So what happens if it was an obligation to deliver a specific thing?
If that's the case, then the debtor will not be liable to the creditor, miss.
Yes, because the principle of genus non quam perit is no longer applicable in this case, class, because we are dealing with specific thing lost due to a fortuitous event. Do you get it now? Okay, good. I will now assume that all of you understood Article 1263. Okay, proceed to the next article. Class dismissed.
Good day, class. As we have agreed, we will be having an oral recit today. So the first lucky person is Miss Tumandao.
Hello, attorney. Good day.
Miss Tumandao, this is your scenario. Eman obliged himself to deliver to Miss Mata a specific photo card of Miss Mata's favorite idol, Jimin. The photo card was signed by Jimin himself and contained a timestamp indicating that it was signed on the day of Miss Mata's birthday. Now, let me ask you this, Miss Tumandao. Is this photo card a generic or determinate thing?
The photo card is a determinate thing, attorney.
Very good. Now, what if the day before Eman was about to deliver the item, his dog bit off the photo card and chewed off the portion with Jimin's signature and timestamp? What happens to the obligation?
I believe that the obligation will be extinguished, attorney.
Why? What is the basis of your answer?
According to Article 1264 of the Civil Code, the courts shall determine whether under the circumstances the partial loss of the object of the obligation is so important as to extinguish the obligation.
Good. You will receive a perfect score, Miss Tumandao. So what? How does Article 1264 apply to our scenario? Yes, Miss Delmar.
In this case, attorney, the signature and timestamp of Jimin is so crucial that its loss distinguishes the entire obligation.
That is correct. But what if the damaged portion of the item is not an important aspect of the obligation?
Then, the obligation will not be extinguished, attorney.
Good. Now, going back to the example where the dog bit off the photo card, is the debtor liable for damages? Yes or no?
Yes, attorney. The debtor failed to take good care of the photo card. She should have placed it out of reach from her dog so as to avoid what happened. Because of this, she shall be obliged to pay the value of the card with indemnity for damages.
Very good, Miss Delmar. Now, class, I will call on my colleague to facilitate the recit from here on out. Be careful, she is more vicious than I am.
Good morning, class. Once again, I am Attorney Mata. So to start this oral recitation, let me first call on Miss Capuno. Yes, Miss Capuno, are you ready?
Yes, attorney.
So, here is the scenario. Mr. Cañete borrowed the car of his girl best friend, Miss Delmar, to take his girlfriend out for a weekend trip. Also, Mr. Cañete promised to return the car by Monday without the need to further demand from Miss Delmar. Now, during their trip, the car was stolen. However, Mr. Cañete swears that he was not at fault as he parked the car at the proper area, and it just disappeared while they were spending quality time at the beach. In this scenario, is Mr. Cañete liable for the loss of the car?
Absolutely, attorney.
What makes you say so, Miss Capuno? Mr. Cañete parked the car at the proper area as any diligent person could. So, how is he at fault?
Article 1265 stipulates that whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault, unless there is proof to the contrary, and without prejudice to the provisions of Article 1165. This presumption does not apply in case of earthquake, flood, storm, or other natural calamity.
Very good. Now, what if the car was damaged due to an earthquake or flood? Is Mr. Cañete still liable for damages? Yes, Miss Mangubat.
The presumption of fault will not apply, attorney, and Mr. Cañete will not be liable for damages as per the last statement of Article 1265.
Good. Now, what if on Tuesday the car was damaged by a fallen tree? Is Mr. Cañete liable for damages?
Yes, attorney, this is because even though Mr. Cañete was not at fault, he is guilty of legal delay. This is under Article 1165, where a debtor who is not at fault is still liable in case he is guilty of legal delay, or if he has promised to deliver the same thing to two or more persons who do not have the same interest.
Bullseye, Miss Mangubat. So, I think that is it for today's class presentation. I hope you learned something. Once again, this has been Attorney Mata. Goodbye and thank you, class.
Thank you and goodbye, Attorney Mata.
Okay, students, let's see if you've done your readings for today. Okay, now my scenario for you is Person M obliged herself to be a magician for Person B's daughter on October 2022. But she had a car accident wherein another car, counterflowing, hit her car, causing a pileup a week prior to the event, resulting in her arms being amputated. So, my question for you is Person M still obliged to perform her obligation? And why? Let me call on Miss Castro.
No, attorney. Person M would not be obliged to perform her obligation. Article 1266 states that the debtor in obligations to do shall also be released when the prestation becomes legally or physically impossible without the fault of the obligor. In the case of Person M, an amputated arm would render her unable to perform her duty as a magician for the party. Thus, the impossibility of the performance would result in the extinction of this obligation. Hence, Person M is not obliged to perform her obligation.
And what kind of impossibility would that be, Miss Castro?
That would be physical impossibility, attorney.
Miss Uymateo, I have a scenario for you. Person E agreed to construct a commercial building for Person A, but the government refused to issue a permit because the area where the construction would take place is a residential area. So now my question is, what kind of impossibility is this?
That would be a legal impossibility, attorney.
Before I proceed, class, we need to remember the two kinds of impossibility under this provision. First, we have physical, and second, we have legal impossibility. Physical impossibility occurs when the obligor dies or becomes physically incapable to perform the obligation. On the other hand, legal impossibility occurs when the obligation cannot be performed because it is rendered impossible by the provision of law, even if it is physically possible. Now, Ms. Uymateo, let me call you once again. I have a scenario for you. Party A is a contractor for Party B, wherein they agreed that they would construct a condominium complex near Mount Mayon on September 30, 2022. But suddenly, days before the construction, the volcano showed extreme signs of eruption. Now, my question is, will Party A still be obliged to perform the obligation?
No, attorney. Party A will not be obliged to start the construction of the condominium complex because under Article 1267, when the service has become so difficult as to manifestly beyond the contemplation of the parties, the obligator may also be released therefrom in whole or in part. In the case you stated, the contractor was unable to foresee the eruption of Mount Mayon, thus is considered a fortuitous event in this specific situation, and the obligor is released from the obligation.
It's good, class, to see that you've all done your readings, and I hope to see this consistency in our future sessions. Class dismissed.
Okay, so good morning everyone. We will be having an oral recitation for today to check if you fully understood the readings I assigned to you last meeting. I will be giving you sample scenarios and I will be asking questions afterwards. Okay, so let's begin with Ms. Mendoza.
Yes, attorney.
So Ms. Mendoza, your scenario will be this. In school, Miss Yu decided to show Mr. Tercino her new Chanel lipstick that she purchased just recently. When this happened, Mr. Tercino envied Miss Yu, and he decided to steal the item and show it to his sister. However, upon showing it to his sister, she accidentally dropped the lipstick and broke the item. So my question is Mr. Tercino still liable to Miss Yu, even if the object stolen was damaged through the fault of a third person?
Yes. This is because the fortuitous event does not exempt the debtor from liability and he must exercise due diligence since it proceeds from a criminal offense.
Okay, that's correct. But can you further elaborate and support your answer?
The given scenario is applicable to Article 1268. So Article 1268 states that when the debt of a thing, certain and determinate, proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, whatever may be the cause for the loss, unless the thing having been offered by him to the person who should receive it, the latter refused without justification to accept it. This article applies only to obligations to deliver definite items that resulted from criminal offenses undertaken by the obligor. Whatever the cause, the debtor shall be liable for covering the item's value if it is lost.
Okay, thank you for your participation, Ms. Mendoza. You may now take a seat. Now, let's proceed to Ms. Roble.
Yes, attorney.
Okay, Ms. Roble, this will be your scenario. So Miss Yu was obliged to deliver a specific set of law books to Mr. Tercino. However, her classmate, Miss Del Castillo, borrowed the books without permission and damaged them. So in this situation, is Miss Yu still liable to Mr. Tercino?
The answer is no. The obligation of Miss Yu has now been extinguished. Therefore, Mr. Tercino now has the legal right to sue Miss Del Castillo for the cost of the law books.
Okay, well said, Ms. Roble. But can you explain the basis for your answer?
According to Article 1269, it states that the obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against third persons by reason of the loss.
So, Ms. Roble, are you saying that the creditor is given the right to proceed against the third person responsible for the loss?
I agree, attorney. If a third person is the one responsible for the loss of the thing, then the creditor is given the right to take action against him. This means that the rights of action of the debtor are now transferred to the creditor from the moment the obligation is extinguished.
Okay, so it seems like you all did your reading assignments. A job well done to everyone. Class is now dismissed. See you next meeting.
Good morning, class. I assumed you have read about the condonation or remission of debt that I told you to study about, particularly the articles 1 to 70 and 1 to 71. Who can volunteer in class and discuss what they have learned and provide an example for each?
Attorney?
Yes, Miss Badiang and Miss Barikit. Kindly discuss in class.
Attorney, Article 1270 tackles condonation or remission, which is the gratuitous abandonment by the creditor of his right against the debtor. Hence, it is a form of donation. A condonation or remission must be gratuitous, must be accepted by the obligor. Parties must have the capacity, must not be inefficient, and it must comply with the form of donation. For example, Isabella is indebted to Amir for the amount of 2,000 pesos. If Amir condones the obligation, which means he will no longer collect the payment from Isabella, and Isabella accepts it, then the condonation or remission is complete.
What a concise but profound explanation. Thank you for that, Miss Badiang. What about Article 1271?
May I, attorney? So, Article 1271 states that the delivery of a private document evidencing a credit made voluntarily by the creditor to the debtor implies the renunciation of the action which the former had against the latter. If in order to nullify this waiver as it should be claimed to be inofficious, the debtor and his heirs may uphold it by proving that the delivery of the document was made in virtue of payment of the debt.
For example, Princess owes Carmel 5,000 pesos accompanied with a promissory note which was signed and given by Princess to Carmel. Should Carmel deliver the promissory note voluntarily to Princess, the presumption is that the debt must have already been settled. If in case no payment was received by Carmel, it must be presumed that the obligation has been remitted.
Thank you for that, Miss Barikit. I hope everyone understood everything. That ends our class for today. See you next meeting.
Good day. Let us pick up where we left off on the condonation or remission of debt. Miss Antiporta, suppose that Ava, by virtue of a promissory note, owes Yumi 10,000 pesos. Yumi insisted for Ava to hold on to the document for the time being. The following month, Yumi sought out Ava to collect the 10,000 pesos. Is Ava liable to make payment?
The law provides under Article 1272 that whenever a private document in which the debt appears is found in the possession of the debtor, it shall be presumed that the creditor delivered it voluntarily unless the contrary is proved.
Now, in their failure to recount exactly their encounter which transpired the previous month, both Ava and Yumi are unsure as to how the promissory note came to the possession of Ava. How does this change your situation?
Since both Yumi and Ava have no idea how the promissory note landed into the hands of the latter, it is presumed that it was actually Yumi herself who delivered the note to Ava. However, such presumption is nullified if Yumi is able to prove otherwise.
Well done. Now let's see if your other blockmates did their homework. Miss Sakai, suppose Maria owes Nadia 30,000 pesos and Maria's close friend, Rain, promised to pay the loan amount if Maria fails to do so. The principal debt is the amount of 30,000 pesos, and the guarantee of Rain is the accessory obligation. If Nadia condones the debt of Maria as a kindness, what consequence does this produce for Rain?
According to Article 1273, the renunciation of the principal debt shall extinguish the accessory obligation, but the waiver of the latter shall leave the former in force. This implies how Maria borrowed money from Nadia and Rain guaranteed the payment of the loan. Nadia remitted the entire obligation of Maria. This remission extinguishes the whole obligation.
So to speak, if what was condoned was only the guarantee of Rain, is Maria's debt of 30,000 pesos extinguished?
Yes, since Rain guaranteed the payment of the loan, the renunciation of the principal debt shall extinguish the accessory obligation, but the waiver of the latter shall leave the former in force.
Very well said. Now, one last question before I dismiss you. Ms. Cobero, answer this for me, please. Suppose Eliza, the debtor, pledged to Amanda the title of a lot she owns as collateral for the payment of her loan. Sometime after that, with the loan still yet to be paid, the lot title was discovered at the hands of Eliza. What does this imply?
In reference to Article 1274, it is presumed that the accessory obligation of pledge has been remitted when the thing pledged after its delivery to the creditor is found in the possession of the debtor or of a third person who owns the thing. This implies that Amanda, the creditor, either consented to the loan without the commitment or she has remitted the pledge. The debtor, Eliza, is still obligated to pay the loan, but the pledge no longer provides payment assurance or security. As a result, it is now a pure loan. However, the creditor can rebut this presumption by confirming that the item was stolen, returned for a repair, etc., in which case there won't be any pardon.
Splendid, everyone! Unfortunately, this is where our session for today ends. I will just simply communicate with their class representative for future instructions.